questions. So I'm not really setting it up. I'm setting it up telling them that I'm going to be assigning it, so they may need to rewrite it with their lender exactly. With the higher terms, the lender's going to come out and establish the amounts and stuff. But right now, what I want to do is just lock it at the agreed upon numbers so that they know that if somebody does come back out, their numbers are still going to be good, that it's a binding deal. And then on the back page of this contract, when we get in the clauses, you'll see where I address the other issues you were talking about. I've got other contingencies in here. If contingencies are not their problem, if they don't want her, then I'm going to get all the contingencies I can get into it.
So your out's gonna be tied into that paragraph if you can't get, your buyer can't get financing. the deal
That's
out.
my ultimate escape clause if I needed to use it.
You said that you always tell them that more than likely I may be assigning this to another buyer or to one of my investors.
It would be a lie in my case because that's what I'm doing. When a motivated seller don't want her, you can be incredibly blunt and honest with them. It's not an issue. Back to the lady in our office the other night that I told her that I needed to put her at risk, but I would represent her, but I wanted to make sure I was going to get paid, you know? It's just because otherwise that's a conversation I got going on in the back of my head, you know, that's it will rise and mess the deal up. And there is no problems with people doing this. You don't need to be slick with them, you know, you just be straight with them, and it'll work way better.
Right.
And it's not an issue.
I mean, because when I was dealing with my property, the deed off, I did tell her, you know, that there could be a potential that may be in partnership or I could be signing this off. So she,
Yeah, that's good.
What percentage rate do you fill in?
Whatever you want, you could do it at like
Something
4%, 5%. I could deny you because I'm not willing to do a 30-year loan for $2,500 and the interest isn't enough.
So it's just, but it has to be filled in because you leave it blank?
No, you don't want to leave anything blank.
Okay.
And Larry, you got the freedom to stop and correct me anywhere through all this. I have no problem with it.
Wait, okay, question. How do you know what the interest rate? I don't understand. How do you know the interest?
If
Oh,
you wanna put
look,
it
watch
low,
this. Watch.
I'm not an engineer, but I'd fall this below them, so.
No, that's a really good question. I mean, I just make it up.
Okay.
You want to put something really low, so you know it's not even out there in the market. You can't
Okay.
get that rate, so it'll be an escape.
Let me ask you a question. Who do you know that would go give you a 30-year loan at 4%?
For $2,500.
For
Nobody.
investment.
Okay, then that's a good reason to get denied on the loan. Now, they don't have a problem with it. I'm just telling you, they don't have a problem with it.
Okay.
It's not even an issue. Don't ask me why, but it's never been an issue. Okay? Okay, type of mortgage. Let's see.
What dates do you fill in if the buyer does not deliver to seller on or before? How far out do you go?
30 days.
30 days?
No, 45, 60. That's a negotiation. You want to put it as far as you can. Now, why would somebody buy off on the fact that it would be 60 days? Because I've had some of my investors that didn't qualify with the lenders, and I've had to take it to another investor to put a second deal together. So that's why I need the 60 days. And yes, I'm going to attempt to get it done in 45 days. Yeah. You just, listen, real estate doesn't move, it moves at a slower pace. So you need to, so what would be some reasons why it would take up to 45 or 60 days to close something? No, other than the fact on the financing.
Title.
Clear the title?
You got to order the
Title.
title work. And this is, you know, and if you're there sitting there and they've got some circumstances you heard about, like some goofed up title work, you can let them know that what's happened in Michigan is we're I think we're number 3 or number 2. We might be number 1 for fraud. And what they've done is the title company requirements are so stringent now that they are very, very stuck with a fine tooth, and it's causing delays. And that's an absolute fact. And we've had people where they came in and signed off a deed, notarized deed, in front of a notary. Title company won't accept it. Title company wants that person to come to their offices, see them sign off. So it's getting really, really a lot more stringent, so. Okay, so we're gonna do like 30 years, the loan and the amount of, we're gonna have that, and the type, we're gonna have private. And the amount of the loan, you're gonna put maximum. And,
Where are you?
well, you can put, you know, that somebody's gonna obtain a maximum loan, like if they needed to put up some of their own money, they could, you could write down the maximum loan. Just, you can just put the amount in though for what you're doing, you're fine.
Oh, okay.
So we were on the mortgage line, now we're gonna go down. You guys are fine.
Okay.
Let's go,
Land contract or purchase money with mortgage provided down payment of student principal balance on
well, we're not gonna, I guess we can address that. If we're gonna buy, if you're asking the seller to do private financing in the state of Michigan, and the state of Michigan is one of 11 states that does contract for deed, okay, which is a land contract. So you might be, if the person owned the house free and clear, and I don't typically run into this, you could ask them to do seller financing. And you would do that by offering either on a land contract or a purchase money mortgage, which means that they're going to do seller financing for you in the form of a mortgage versus a land contract. And a land contract is where the deed stays with the person selling it to you. They're the deed holder, and you have a contract to buy the property from them. And when you pay the property off, then they give the deed to you. In a mortgage, the owner of the property deeds the property to you and records a mortgage against the property, a lien. And when you pay the mortgage off, he gives you a discharge of mortgage.
Can that also be viewed as like seller's second? I mean, seller, no.
It's not a second. That's where somebody would own the property and they're providing 100% financing for you, the seller. So I have not been using that much recently, but if you had a free and clear property and you're a motivated seller, you could certainly ask for seller financing. And that would be the next, that's what that next clause
If
is.
you're not, what do you put in the blank, just NA or, because you got to fill in all those blanks, right?
Yeah, you could just put in a,
If you're not using that paragraph, you can cross it out, is that correct?
I've taken an ink pen and drawn a line through the whole paragraph and gone down.
Hey, Mark, just a brief question. When you say that the owner has to have owned the house free and clear, is that total definite when it comes to seller financing? Or can a person have a mortgage on the house, lots of equity, and do seller financing?
All right, so I'm gonna answer this the best I can. If they bought the house and they bought it on a land contract, they could sell it on a second land contract. Unless the person they bought it from had a due on sale clause in their land contract.
Okay.
And in the state of Michigan, that particular thing has been ruled on, sometimes like where a land contract to do on sale wasn't allowed, and another time it was ruled where it was allowed. So I don't know what the current law is on that. If you have a mortgage on the property, an existing mortgage, and you're now reselling it on a land contract, it's my understanding that you've actually committed a crime on that. And that you've not been, and Gary Sagatti, who teaches continuing ed, who's a real estate attorney, explained that to me. And that's how I used to do a lot of stuff. I'd have an existing mortgage and then resell it on a land contract and even sell the paper off. I don't know that. That's why you need to talk to an attorney on that stuff.
Yeah, and also probably have the attorney look at their mortgage
So-
note.
That's paragraph 17 in the mortgage clause, and for about 20 years, all of the banks and mortgage companies have held that assigning anything that changes who the owner is or changes the owner's interest activates that due on sale.
Right. And we're gonna get into that in the next paragraph. But that's not breaking the law, that's breaking the contract.
Right.
And
So take
we
your
are
mortgage-
going to break the contract, okay? I'm gonna show you how to break the contract, because I break the contract.
Right.
okay? But I don't want you to break the law. And what I'm saying is when you have a house with a mortgage on that house, and you're now reselling that house on a second land contract, it's my understanding, based upon going to continuing education in a real estate class, that I was violating the law. I never thought that that was a violation of the law, but it's an actually, because of what you're doing is, I can't even remember what he said, but he told me it was a violation of the law, so that's all I know. But now, we are going to violate the due on sale clause on land, on a mortgage, and that's the next clause we're gonna come to. And this is for a deed over. So, now I want you to understand, this is what Javon just did. She took, somebody wanted out of a house, wanted to walk away from it. So, they were ready to just deed the house off to her. But she's way better to have a contract agreeing to that up front, right? So that she can control it. And plus, I didn't want her to go record the deed into her LLC or into her name, because she doesn't really know the outcome. So she just wants the contract to get the deed. So let's go over what we did here. This is an assumption of existing financing. The buyer to pay a sum of, she gave him $1, to assume the seller's existing mortgage, or it could be a land contract. Herein, or I'm sorry, which has a balance of, so now you're gonna find out what that existing mortgage, in your case, that it had a balance mortgage of 186.
How do you know if the seller's interest is assignable?
It's not. Technically, we're violating the contract. Let me get through the whole thing, and then you can come back and attack me from an attorney's point of view and see how we did, okay? Okay, so we got an assumption of existing financing. Buyer to pay a sum of $1 to assume the seller's existing mortgage or / land contract, which has a balance of $185,000, which the buyer agrees to take subject to. So when you take something subject to, you're not saying that you're going to agree and assume to pay the underlying, you're taking it subject to that underlying. And then we're going to add more clarity to it. Should the balance be found to be higher than that stated herein, the difference shall be deducted from the amount paid to assume the said mortgage / land contract. Completion, the complete copy of said mortgage / land contract shall be provided to the buyer within 3 days of the seller's acceptance hereof for the buyer's review and satisfaction as to the terms thereof. If the buyer is dissatisfied with the terms or the conditions, the buyer may void this agreement within 7 days from the receipt of the said documents by written notice to the seller or the seller's agents. The seller agrees to transfer or assign the credit or any sums being held in escrow under the mortgage / land contract to the buyer at no cost to the buyer. So if there's an escrow, they're going to assign that over. Further, it is agreed and understood that the presence of a due on sale clause in said mortgage / land contract shall not act to void or any way affect this contract. The seller understands that understands that the consummation of the sale or transfer of the premise shall not relieve the seller of any liability, and that the seller may have under the land contract or the mortgage to which the premises are subject, unless otherwise agreed to by the vendor or the lender as required by law or regulation. So in other words, you're not agreeing to assume and pay that, and you're telling them you're not stepping into that liability position. So why would somebody give you their house, right? Just here's the deed to my property, and I'm signing this. Why would they do that?
They're desperate.
Well, because they're a don't wanter. You're dealing with somebody that wants to walk away. That's somebody that doesn't. So now, what you're looking for is where the second mortgage is on the property, where there's other areas that can be negotiated in the thing. You just want to gain control of it. You're also, don't forget, you're a realtor. You can start listing the property and start reducing the price. You're going to get paid. So she's now gained control of the property. Now, I went to Las Vegas years back, and there was 500 people in in a great big conference room. And the guy leading the course, his name was Jack Miller. If you ever, I don't even know if he still teaches real estate, but if you ever get an opportunity to go listen to him or see him, like all the gurus, like Robert Allen, all of them, that's where they started in his classes. And you can't write down the information fast enough. There's another guy named Peter Fortunato that taught with him, and then John Schwab taught with him, and they all hung together. He asked everybody in that room, and everybody in that room was people like myself that own a lot of property, that have taken over stuff with due-on sales on them. He asked the people in that room, how many of you have taken over properties, had them deeded off with due-on sales? Every hand in the room almost went up. And then he asked the question, how many of you have been foreclosed on? They all went down. So, technically the mortgage company can foreclose on you. As a rule, they don't. And I'm gonna say in this market, the probability of that's very small. If you don't make the payments, you're gonna get foreclosed on. And if you call up the mortgage company and say, hey, I just took this thing over, blah, 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 you could be in for a rough ride too.
So you don't have to tell them that you have just gone.
She isn't doing anything at this point.
Okay.
All she's doing is getting a binding purchase agreement signed. She's got the deed, she has not recorded, she's holding it.
You recommend that people that do this, when they take over the payments and continue to send them to the cell bank, do you recommend that they not make any notification as to why the monthly check is coming from a different source so that you don't tip them off?
Oh, well, they deeded it to my limited liability company, so I'm gonna state that I'm now managing the property, and this is a limited liability company managing the property. Here's a copy of the power of attorney allowing me as a management company if they want to see.
You're not going to tell them that it's been deeded to you. You're just
Mhm.
going to say that you're managing the property.
Correct.
And that the checks, the monthly mortgage checks will be coming from you. And are you also going to ask them to send the tax notices and insurance
Yes.
notices to your management company?
Yes,
So
to
you-
that entity.
Okay, so you do fill something out and get the change of address basically sent into the lender, so.
Well, right now, all I got's a motivated seller and a deed off. I'm not doing a ding dong thing, I'm just gathering, I've gotten a deal on my
All right,
thing, you know, my.
all right, that comes later,
Uh,
later.
If she elected, if there was equity in that house and she elected to do that and keep that house, so there's a couple things can happen. So here's one, this is before the sheriff's sale, right?
Right.
So we know that she can catch the payments up. So one of her options is to do a rent to own and attract people that have real money to bring to the table to catch up her payments on the house that just got deeded over. That's an option to her. Another option she has is to proceed with the short sale process, to list the house and do that. So you see, pretty much any direction it goes, if she's doing her job and lowering the price, she should be a winner in this deal. And $187,000, that's a nice commission. Even if another agent brought the deal in, she'll still be looking at 3%.
If they're escrowing taxes in the previous owner's name, if you're the management company, do you ask the bank or mortgage company to change the
No.
name on the escrow account?
No, here's how we
You
handle that.
let that sleeping dog lie.
No, we don't let it lie. So, Javon, you get to come up because this is good practice for you.
Oh.
You're gonna tell him, we're gonna do,
Yeah, yeah.
yeah, come on up. So, because she just did this, so what were the, so on a deed over, what were the documents you had signed when you went and met with the owner?
Quick claim deed, the warranty deed document, power of attorney, purchase agreement that we wrote out, and a couple of blank purchase agreements. Disclosure, seller, the disclosures, because I'm an agent, the seller disclosure, and then the lead-based paint disclosure, and then the agency disclosure, where I have to describe to them the various types of agency relationships you can have. That's it.
Do you need to do the lead-based paint disclosure if the house was built after, what is it, 1970?
Yeah, and then
Yes.
there's an option that you check off to say it was built after this time.
Oh, so you have to disclose, you have to provide that in any case, whether it was built
Right, but yeah,
After
yeah.
you-
On that lead-based disclosure, it'll say it was built after 1972, and then the seller is saying that, and so, and they sign off on that.
All right, so do you see inside her doing that, if the house had a fire tomorrow, and they had a good insurance policy on it, she now has the ability to hire a public adjuster to represent her. When they send the insurance check in to be signed, she's got a power of attorney to be able to sign their check. If there's an overpayment in the escrow payment, if some date later when she does sell the house and the escrow check comes back, it's gonna come back. All the payment coupons and everything are already coming to her management company, to her LLC. So everything's being redirected, so she's got control. And why she had the blank purchase agreements to be signed is in case she has to do a short sale. She's gotta bring an offer into the bank. She wanted to get everything in case the seller got in their car and drove to Vegas tomorrow, or left town. So she's gotta be able to have everything so she can function at a later date, which meant she had to take them to a bank to get everything, all the notarizing done, everything done.
I actually had to come to the house.
That's perfect.
So you're getting a deed to get control, and it gives you multiple options of what you can do with the property then.
Yeah, now she isn't, if I was at a house and somebody wanted to deed off, and then I'm not gonna go record that deed, because if you told me you bought that house, then I'd be over the next day to slip and fall, and put some glass in my hand and go like that and call Larry. Or call Larry to find out who to call. And then I could sue you because you didn't have insurance, right? All she's gonna record is her claim of interest on a purchase agreement, we'll get to that, allows her to file a claim of interest at this point.
Right, and I had that form filled out and notarized too.
Yeah.
A quick question on notary. Should we get our notary license? But we can't notarize
You can't
documents
notarize
that we sign,
documents.
right?
Yeah.
You know what, I'm gonna recommend that, you just take the people to the bank and stuff. And I'm gonna really recommend against anybody in this room considering ever becoming a notary. Because all you do is put yourself in liability exposure. And I've seen lots of people get in trouble with that. So, because you'll have everybody and their brothers saying, I swear, here's a copy of their driver's license, would you just notarize this one thing for me? And it just puts you in a position to have to say no to people that you would prefer not to say no to. You know what I'm saying? It's just, and unless you really plan on making a lot of money with it and sticking to the rules and all that stuff. But there's a lot more requirements to be a notary. They enacted a new notary thing where you have to keep a log, you have to, I forget what all it is. And then there's other things like a good notary would get a copy of the driver's license, right? That's now a violation to get a copy of the driver's license. So like you could be breaking the law and there's all these regulations you don't even know you're breaking it. So I'm gonna recommend not doing it. I don't know. What's the advantages of being a notary? You know, Larry?
It's expedient if you have to get some documents notarized, that's all.
Yeah.
And like you say, it's better to let somebody else do the notary at the bank.
Yeah.
But yeah.
I mean, we got a bank, 3 or 4 banks within a couple blocks of us, so I just do that. And we do have a notary in our office, but I just didn't go to the bank. It's easier to get them to notarize than it is him, because he's like a stickler. So, survey, or there's a commercial situation. Possession, I always go for immediate possession. So if you'll look, it says, the seller shall tender the buyer the premise within X number of days of closing. The second one there I circled, it says immediate. And what immediate means is when you close the property, the property is vacant. If you've got somebody that's in a house, this is a question that will come up to you time and time again if you chase foreclosures. If they're living in the house and they want to stay in the house and they'll rent it from you and do a lease option with you. You do not want to do that. There's tons of court cases on the books right now that say that so I'm being foreclosed on, Peter comes in and I couldn't make my payment, but I explained to Peter I got my job back, my wife's now working, I can make the payments. He goes, oh, it looks good to me. I'll resell you the house, you know, I'm gonna buy it at $100,000, I'll resell it to you for $140,000 on a lease option. So then, later, I quit making payments to Peter. So then Peter takes me away in lieutenant court, and then at that point, I go in front of the judge and say, I had equitable interest in this house, this is a usurious deal, and, you know, and the judge looks and says, yeah, if it looks like a duck and walks like a duck, it's a duck. So there's all kinds of case rulings already on there. Leslie London, who does the majority of the foreclosures in Oakland County, just went into circuit court and now is appealing to the Supreme Court doing exactly that, where she bought the house and then kept the people in. And she lost in circuit court, she's now in the state court, or the Supreme Court of Michigan. And then there's another large guy, I know him, I can't think of his name though, Stanley Van Rinken. He's already got rulings against him. He owned like 1,100 properties. So you don't want to do that.
So there's not some verbiage on a contract that you can write up everything else? Isn't there something you can write up in a
Yeah,
case
you
like
can go back to those same people and buy the house for $100,000 and then resell it to them maybe for like $105,000 on an option, because then it's not usury. You're okay. See, they're gonna say, look, it's a loan. All you did was refi these people.
Oh, okay.
So you don't wanna do that.
Okay.
And you can, and people do it all day long. All day long, people do this, and I've never had a problem with it. I'm just saying, there's already all kinds of cases on file, so why go looking for trouble? So I don't do that. You could put them into another house and do a lease option with them.
So let's say they were getting ready to move the house, you buy it, and then they get a mortgage later, and you sell to them at like 10,000 higher, that's usury. That makes sense.
If you did a lease option with them, if they were, I'm gonna recommend that you get the people out of the house. If you don't wanna do that, it's okay. You know, I'm just giving, this is my opinion. It's nothing, you know.
I have to say, basically every time you go to a lawsuit, literally the only winner is the lawyer. He's gonna collect his fee. You
Yeah.
might as well avoid it,
You know, yeah.
avoid the lawsuit.
And they're going to make sure that they prove that you're right
Absolutely.
and then the other person gets to be wrong. Even though it cost you $50,000 to be right, we're gonna make them wrong. Okay? That's the premise. And that is the best advice here. I mean, it doesn't get any better than that. And I've got to go down the other road more than once, so if I can avoid it, I want to avoid that at all costs. Okay. Back to the possession. So we want immediate possession. That's why I want to get the previous owner out of the house, okay? Because I can't resell it. You can't resell the house with somebody in it. If you're doing one that's a foreclosure, it's tough to get them out. Now, she's got the owner still in this house, but she's working on moving the owner into a lease option situation, somebody she knows really well. And if the only way you can get it is with them in it, what the heck, go ahead and take it with them in it, you know? I mean, you've now gained control of the house, okay?
And in a foreclosure situation, if you have the contract says immediate possession of the house, and the seller decided they want to stay longer, can you evict them? What is the process on that? What is?
Well, that's why there's a clause in here that you go inspect the property before the closing to make sure they're out. And you want to make sure that you've looked at the property before the closing, that they've actually moved out of the house.
And if they're not?
Oh, then at that, so there's a couple of things. We'll get to some of those, but at that point, you don't close. Go ahead.
You made a reference to the usury statute. Are you going to review it for the class?
I'm not an attorney, so I know that, here's what with usury, you can only use usury as a defense. So like if Peter gives me a loan and the legal, it's a personal loan and a note, and he gives me a note for $10,000 and he's got 18% on it, it's just a personal note. The max legal amount 7%. So I make payments for 2 years and I say, you know what, I can't make payments on this anymore. I know that a judge can come back on him and declare everything I paid towards the principal and put some major fines against him, but I can only use that as a defense. He has to bring suit against me first. That's all I know about it, and then you can add.
Well, every state has their own usury laws. In Michigan, when there are loans between individuals, the maximum rate between individuals for private loans is 7%. Corporations, 24%, and there is an exception for land contracts. And I don't remember how high.
It's
11%.
11%, but if it's your personal residence, it can go up to another higher amount. I don't know what that is.
Right, so you should look it up and understand. Now, if Mark's exactly right. If you've charged someone a usurious amount in your loan documents, they'll still owe you the principal, but the judge, if you go to court, can cancel the usurious interest. And that's why you need to be very
They
careful.
can slap some penalties on you too.
Right.
Ask me how I know.
You got to spank.
Yeah, I've seen it, yeah.
Isn't that the same, isn't that the same with rent too? There's so much you can,
Well, okay, we're not doing landlord
Yeah, I
tenant,
know.
but the maximum amount of deposit you can take is a month and a half security deposit, okay?
So hard money lenders would have a hard time charging 12%.
But,
Hard money lenders?
no, they can go up to 24% because they're a licensed lender.
I see.
See, if you're, okay, hang on, let me back up. If you're a licensed lender in the state of Michigan, which we were a licensed lender, server, and broker one of mortgages, we could go all the way up to the 24%. Now, we could do that in a couple different ways. We could charge you 15% interest and then some points, 10 points, or whatever, you know, and then we do it for, sometimes we had to expand the loans out to 2 years in order to stay under the law, to make sure we were in the legal limits. So that's what hard money lenders do.
But
Like probably
me to
15.
you would be simple.
From you to me, yeah, well, that would be a personal note. If it had a mortgage attached, I think it might be 11%. I don't know that, you've got to check,
Okay.
okay? But what you can do is, if you are a deep-pocketed person and you can qualify for fat cat status, and that means that you've got a certain net worth, then you can go to a lender, a licensed lender, and then loan the money out at the 24%. But that closes through a licensed lender regulated by the state of Michigan. So that's another way that you can do that, okay? But, you know, like, where you start to get in trouble is, well, let me incorporate you, you know, and then you're, you know, at the back in front of the judge explaining if it looks like a duck and walks like a duck, you know?
On the other hand, if you suggested that they go to a lawyer and find out if there were any creative ways to do it, and you didn't propose it, and their lawyer proposed them, that they incorporate, then you don't have the problem in front of the judge, because they had separate counsel and arm's length dealing and full disclosure.
Okay, there you go. Okay, we're back to possession. So we're gonna get immediate possession. Then on the last line, it says, if the premise is vacant, the buyer shall be provided with a full set of keys upon the acceptance of this offer. So in other words, you need the ability to resell it. If the seller occupies the property after the closing, the seller shall pay the buyer rent as detailed in the attached here too. So in other words, I should go up to the, let me just read the whole thing. So immediately upon completion of the closing and upon the seller's acceptance and the buyer's acceptance of the counteroffer, or during the time until the closing of the sale, the buyer shall have the right to enter upon the premises during reasonable business hours for the purpose of inspections, tests, to show the property to potential tenants or to purchasers, or for resale by the buyer. So in other words, typically people are putting that clause in or writing in addition, you know, in their addendum. So you've already got it in the addendum or in your purchase agreement, so you don't have to worry about putting that in there. So that means when you leave the house, you need to have a set of keys to it, or you need to have your lockbox on it. to be able to, it does you no good to tie something up where somebody's occupying, you can't sell it unless you've got access to it. It's a complete waste of time if you don't have access to a property to be tying it up. Earnest money, you know, that's where I'm gonna give 0 deposit. And I'm gonna write it right in. And then, if you're the only 2 people there signing the deal, who would witness your signatures? And is that required? So if I'm buying Lori's house, she's the seller, she's gonna sign as the seller, I'm gonna sign as the buyer, who's gonna witness my signature? I can have her witness it, I mean, it's. But is that necessary?
No.
Correct. No, it's not
No.
necessary. And the brokerage fee, I'm gonna write 0 in my case, but if you're a licensed realtor and you've got a deal with your broker, then you're gonna just have to deal with it. But that, if you're gonna get into the investment business, you need to find a broker that you can work with. So you need to have a broker that says, look, if I'm tying stuff up or I'm going to buy something, I'm promising you that I'm buying it to resell it, you get paid when on the resell. But you need to, if you're a real estate agent doing something, you need to disclose to your broker, this is what I've done. The broker needs to be aware of it, because the broker is liable for whatever you do. So you really want to think about, if you ever want to become a broker of an office and put a jillion agents under you, you really want to think about what you're doing, because you're liable for everything all those people do.
So for those of us who are not realtors, what would we fill in on that line? The buyer gives blank.
You could just draw a line through it, it's not applicable, you know.
You can put just 0.
Yeah, or draw a line through it, okay?
Hey, Mark,
Yes,
as I go through this, I'm just trying to distinguish between what I would do as a realtor versus an investor. And when it gets to number 6 in terms of possession, as a realtor, if the person is still in the house, we would normally just call them to see if they're available if someone wants to come look at the home. We don't collect the keys, or the keys may be in a lockbox if it's vacant. In this particular clause, and as an investor, if they're in the house, do we still request the keys if they're living in the house, or do we still create the,
you gotta
have your
ask
phone number?
you gotta ask your broker that question. In my
Okay,
case,
see, that's what I need to
I
know.
want a lockbox in the keys,
Mhm.
and I wanna be able to show that property.
It'd probably be
And
the
I'm
same
dealing with
scenario.
adult wanters, and realtors that, you know, you can work an arrangement out with them, that you're gonna call and let them know that people are coming over. You absolutely do that, but it's a waste of your time. If you're not an agent, you can still have keys and have possession the
So
same
that's why I
way.
wanted you to present that clearly,
Yeah.
so people know it is the same scenario.
Yeah, it's the same scenario. If you wanna have possession, you gotta have possession, you can't get it resold if you don't.
Because it says at closing, so that language is kind of confusing too.
Who provides the lockbox?
Well, if you can get them to pay for it, everything's a negotiation, that'd be wonderful. See if you can get $12 on the spot, or 20 bucks or whatever. No, you're gonna have the lockbox. And where can you get lockboxes? You can buy them at Home Depot.
About $20.
They're like 20 bucks or something.
Some are dial and some are push button, is one preferred over the
20 to 30.
You're, however old you are, if you're used to dialing, or if you're like, it's whatever you like.
I would avoid,
We get the deal, like, you know,
dialing.
these people are calling him, and
We
he's
don't
saying,
turn it good
when we
enough,
go over
somebody
there, we wanna
figure
have
out.
everything
Take
signed.
it off.
And this is the first time we've approached these people. And then we're signing, and then we're telling them, get out, what, the keys? I mean,
They're not getting out of the property now, they're getting out at closing.
what
But you are asking them for
At
keys.
closing.
That's why I wanted that clarity, because it.
Yeah, no, how can
I'm
I,
lost here.
yeah, no, I'm asking for the keys.
You asked for the keys.
They don't want it. If they're still in the house, I still need to be able to get my inspectors in, I need to be able to get my partners in, I need to be able to have access to the property.
Whatever
Now, if they're not willing to give it to you, they're
You gotta
willing to
call
say,
them.
but I've got somebody here at the house all the time, all you have to do is call. That's, you know, like I said, then you you're not gonna do that, you know, you're just, it's all a negotiation. It's not gonna stop you. You can, don't get hung up on if they won't give you the keys that you're not gonna get it signed, okay? You wanna ask for everything when you go there. This pretty much has everything except everything in it that I can think of. And that's why it's 2 pages, that's why there's no room for additional conditions, because I keep adding all the additional conditions. And it's my standard purchase agreement. And I'm gonna ask them to take it to their attorney. And what's weird is, there's not very many attorneys. Larry's a major exception to attorneys, because he actually looks at stuff and reads it and does that kind of stuff. A lot of attorneys will take this to, they'll take it to like a UAW attorney, or, I'm not trying to downplay UAW attorneys, but they don't look, there's not as, a lot of times there's not as much scrutiny at the purchase agreement. They come back with, well, you misspelled my client's name, we need to change this, you had no tax prorations. And there's a jillion other things in there, and you've got so much in there, they're just lining through it, you know. And then you run into an attorney that wants to like cheese the client, and he'll rewrite this entire purchase agreement and go through. I had one, he must have charged the client, I don't know how many hours of time redoing a whole PA on just an offer. It was ridiculous. So it's all a negotiation, but I'm saying, if I don't have many attorneys kill deals, and the fact of it is if you've got the house bought for $15,000, if you're paying prorations and you're redoing it on the attorney's farm, that's fine.
So the attorney who rewrote that contract, did that kill the deal for you?
I didn't do that deal, but it wasn't over his rewrite, it was over the fact that I couldn't get the property sold. We basically, he just took out stuff like prorations and just, I never seen a contract so lined up with so many, it was unbelievable. But the point is, he charged his client for all that, you know, and there wasn't even like it could have been done simply by, you know, subject to my attorney putting this on his purchase agreement or something. You had those clauses. Another thing you could do is, you know, it comes the day of the closing and you've written up this contract says that the property will be broom clean at the time of closing. Okay, and when you get there, it's not broom clean, which means everything's out of the house. The best way to get it cleaned up is, because what they'll do is tell you, you know, my cousin's gonna be over at 4 o'clock tomorrow, I'm gonna take the rest of it out of there. It's not an issue, we're gonna escrow $5,000. And if you don't clean it, then my contractor will come clean it, and I'm gonna keep the $5,000. You're pretty much assured it'll get cleaned out when it was supposed to be cleaned out.
You put that in the offer to purchase?
Yeah, well, you amend it at that point, because you come to a closing table, they haven't come out, they wanna close and get their money, but they're still got garbage in the house, so you need to, you're never gonna get anything after it's closed from somebody, so you gotta bake it in before the closing. Or would you say perk it in, or pop it in, or whatever the word is, bubble it in. Yeah, that sounds better than baking. So you bubble it in at that point.
And the garbage up front too, right? Because you'll see piles.
Well, my
When they haul it
purchase
out.
agreement says that the house has to be, you know, broom clean and the yard rake clean.
So all the garbage removed.
Yeah, no trash.
Right.
And at that point, he's saying.
And they'll sign deals with you and there'll still be trash at the day. At that point, you have to address it. So let's go to page, go ahead.
Can you unilaterally say that my escrow number is $5,000 without having put it in the previous contract? Can you just make up a number at closing?
Well, at closing, if the property's not cleaned out, you would be way better to put it in ahead of time. Like if the house is not room clean, you could add that clause. That's why this thing keeps getting adjusted. So he's got a very good point. That should probably be a new clause added in.
You can add that as a.
Listen, you just said a binding contract is written on a napkin. I agree to sell you my house for $10,000 and I'm going to go get a mortgage and we're going to close in 30 days. It doesn't say anything about title work or any of the other conditions, right? But that is a binding contract. But I should remember to address that you have to give me title insurance and stuff. If I didn't do that, it doesn't matter, we got a deal to buy the house and close, at least it's locked up.
It's a lot better to put those clauses in when the tears are hot and flowing than to have theatrics and drama at the closing. If it's been put in, and if the lawyer wants to squawk about the size of the numbers, say if they perform and I got a clean house, it's a non-issue. that's what I would be doing, but I certainly.
At least they're all addressed up front
Yeah.
and negotiated out, so.
Added to the
You can add addendum on third page.
Right. Well, just
You guys can put as much stuff in here as you want, but there's only a couple lines left.
But you also have to balance that out with, you don't want the contract to be so restrictive where they say forget it. Because that could, so you balance it out.
Yeah, this is pretty heavy duty though, guys.
Right, it
You know.
is.
But it's not if you're a motivated seller, it's not an issue.
Right.
And most of the time, there's not even an issue with the attorney part of it either, believe it or not.
Right, 'cause
That's because, why?
Most lawyers are lazy and they don't want to interfere with the deal.
They don't even read it. So, they just collect some money and go, okay, that's why it does need to look like a standard purchase agreement. Whatever that is.
right.
How
Okay.
often you run into a home that is not included?
On investor buys, pretty much all of them. I mean, they're, so that's an issue that, you know.
Could I ask you
Sure.
a question about that? You created a number, $5,000. Now, are you creating that number to cover all kinds of cleaning contingencies, or, and you said, I'm keeping it all? Or are you going to say, I'm putting it there and I will send you an itemized bill and give you the balance back? What are you doing with it? You're saying, I'm gonna take the deposit
I'm gonna keep it all because I don't wanna go over there and send somebody over to clean it. So you gotta make the number high enough that they're gonna go do the work. And if they don't do the work, it's gonna make you smile.
So you're saying you smile a lot, is what you're saying. Because you say you find these houses kind of in bad shape, so you're saying that this,
Typically, I'm not, that's usually not an issue on the clean out stuff because of the way I'm doing business. Don't forget, I'm just assigning the PA. So all the stuff he just talked about is actually happening. I'm just not present for the drama.
I see. Okay.
But I could probably make a lot of extra money by asking if I could sell tickets to the closing. That way, then people could come see what not to do, you know? So that's why I'm not, but when I was doing it, it was absolutely, yeah, it was like, and that's, I always made sure I had somebody else come to the closing to enjoy that great experience. And I'll give you an example, like Tony Naback, who's my partner, does the net sheets and spells everything out, she's great. Roy Frank, who's my partner, doesn't address that. So who do you think has more drama at the closing tables?
Roy.
Roy, yeah. So, well, no, it doesn't matter because see, some people want certain things in their life. It's the truth. I mean, you're the one that creates your world, so you just structure it that way. People create the structures and wonder why the same thing keeps happening. You know, and I can really relate to that because I've done a lot of it myself. So property taxes, that's clause 8. That's where we're at. We're on the second page. Oh, well, we're back to the first page. The parties are going to sign. So if you're there and you've written the deal, all you need is the buyer's signature and the seller's signature. Because there's like the thing called offer, and then you deliver, they accept, and it comes back. Go ahead.
The brokers have to make absolutely certain that the person doing the signing is the person that actually owns the property, and they can't get just one spouse to sign. If it's held by husband and wife, tenancy by the entirety, which is legalese for the married couple, they can't get just one to sign, it's no good. So you better know how the property is being held on either the title work or at the Register of Deeds office, and whoever is the owner is the only person that can sign that sales contract.
Okay, I'm sorry, I'm gonna ask this question too. You all keep talking about a very low amount of money, the 2,500 or 3,000 or 3. Where is this
We
low,
just made that up. This came out of here.
for the purpose of this class?
Yeah,
Okay,
we want it
but
to be
when we're doing
200,000.
this,
we can't
there's
do
a reasonable
200,000.
figure placed in here? I mean, I'm not sure. I
Depending on the property at hand.
Actually, to be honest with you, that's a very reasonable figure for some of the properties I buy.
Oh, okay,
But they're different than
okay.
her $185,000 property.
Okay. All right.
And see, in my foreclosure, all I can do is ask her, she doesn't have any money. So I could just say, make sure you have all your stuff out, but I really can't, I don't see where I can say, I'm gonna charge you $5,000. With what? She doesn't have $5,000.
The lady's still in the house, she's working on doing a lease option to another property with her.
Okay.
So, there is no rule, so you have to adjust to the circumstances, okay? So, this is not like the Bible or anything like that. This is just some made-up stuff. In fact, none of it's the truth, they just made it up. You get to try what you like about it, you know? Because that's all I've done, is I've gone in through trial and error and taken other stuff, you know? And so, and Larry just brought up a great point about putting the thing in there about the $5,000. That would be a contribution to whoever I'm assigning the purchase agreement to. It could also be a hindrance in getting my purchase agreement signed. That's the flip side. But they usually don't care. But when you're a don't want and you're ready to walk away, getting the trash out of the house is not, you don't care about that either. Sometimes, you know, so you gotta adjust accordingly.
It looks like line number 30 and line number 33 are the same. You need both of them signed?
Line number 30, oh, we're definitely.
Yeah.
No, one is seller, one is buyer. Buyer.
Oh, you're right.
You
Correct.
sign the contract first, that the seller agrees to it. And number 34 is you acknowledge that you accepted the offer, basically.
Oh,
Well, that's a counter offer.
number 33
Okay.
though.
See, typical real estate, the real estate agent runs the offer out. I'm presenting this offer, the person counters it, they run it back. They initial, and you come back for another signature. So if you got a meeting of the minds, you just need 2 signatures.
Just that line number 30.
Or you can just go ahead and have them sign everywhere. Everywhere it says sign, okay. That's probably easier for you. Just do that. You're good then.
Take all the signature lines out and add more addendums.
Yeah. Mark?
Like you said, 15 wouldn't really be legally necessary. I guess that's just in there to avoid drama, as you said.
Okay, we're gonna get to that. Why don't we go through it? So paragraph 15 on the assignment is not necessary. All purchase agreements in the state of Michigan are assignable, unless they state that they're not assignable, you know, so. You don't need and/or signs or anything. You can assign a purchase agreement in the state of Michigan.
But if you get that out up front, with the closing.
It's just making it, I'm making it clear because everything I'm doing, I'm gonna assign. So that's why it's in there. It's just, it's back to trying to avoid the drama. So, but yeah, you know what the definition of trying is? It's looking good while failing. Anytime you hear somebody say, I'm trying to get that done, really listen to what they're saying. They're saying, I'm not succeeding at it, but it's kind of a looking good answer. So they say, I'm trying to get this done. Just, if you're listening to their conversation, it's, you know, no, I'm doing it, you know. Go ahead.
We've already explained that the statute of frauds requires that every interest in real estate be in writing, but in every state in the union, there's also something called the parole evidence rule. It's spelled P-R-O-L, and it means that you can't introduce allegations of a verbal conversation to explain a document that's clear on its face. So if you have a side conversation about what's going to happen to the garbage or how much money's going to be taken out, and it's not in writing, and somebody wants to explain, but we had an agreement at the closing table and you said that it never comes in. If the document is clear on its face and you don't have it in writing, none of the verbal conversation comes into evidence at any trial.
So that's a really good point. So on those ones where we did have a agreement, like we're at the closing table and they didn't clean out the house and we had to put a bigger deposit, all that was done in writing at that point and done as an addendum to the purchase agreement that superseded the previous ones, you know, so. Okay, so does everybody get the front page now? This is the second page, or the back page, it could be, is, we're gonna start with property taxes. So in the state of Michigan, in Wayne, Oakland, Macomb, Washtenaw, Livingston County, how are taxes paid? Are they paid in advance, or are they paid in arrears? In advance, okay? So, or if they were paid in arrears, would you want to get your tax, and you're selling a property, would you want to get the property taxes prorated? Let's say we're now in Gaylord, Michigan. Taxes are paid in arrears there. So would you want to prorate the taxes? And the answer would be no. Because taxes are prepaid, so when you start prorating it, it works just the opposite there. So I think, maybe I said that wrong.
You said that wrong.
No, hang on. If taxes, I'll ask Larry. Larry, if taxes are paid in arrears, not paid in advance, like they are in Oakland County, but we're in Gaylord, Michigan, and they're paid in arrears, would I want tax prorations?
Yeah, because you're.
Yeah, because you get money back.
No, they're paid in arrears
Be the buyer or the seller.
from the buyer. I don't think you want taxes prorated there.
Oh, see, I'm thinking about the seller, okay, no.
You have to always ask, are you
Think
the
about the
buyer
seller.
or the seller?
So we're the buyer, we're just talking about buyer favorable purchase agreement, and always look in my forms in the bottom, BF, buyer favorable,
Right,
okay?
you don't want proration.
Not if you're on it.
Well, in Oakland, Wayne, and that, you want to be able to have, you want to get their prepaid taxes. So in order to get their prepaid taxes, you're gonna have no tax prorations, which means you keep their prorated taxes.
Do you want to explain the difference at this point between due date and fiscal year?
I'll let you.
No, I'm not volunteering for that. No,
Maybe another class.
There are two ways of computing taxes for property. One is fiscal year, one is due date. And it's been too long since I remembered which one favors the buyer and which one favors the seller. But it could be the difference of hundreds or even thousands of dollars in which way you get your tax escrows when you close the deal. So you always have to remember to ask, when you're writing up your offer, I believe it was fiscal year that favored the purchaser and due date that favored the seller. But I'm going back 25 years.
Yeah, and I don't even know, so.